There we go. So thank you, Betsy. Thanks to all of you for participating today. It's great to be here. Again, my name is Dick Mendel. I'm a senior research fellow at the Sentencing Project, and today I'll be talking to you about restorative justice diversion. So that's not just restorative justice, but it's restorative justice for youth. And at the front end, the diversion phase of the justice process. I'll be concentrating a lot on restorative justice's advantages as a tool to provide meaningful accountability for youth who run into problems with the law. So let me begin providing you some background and context. Why focus on diversion and why restorative justice diversion specifically, and why worry about accountability? Over the past few years, I've written, as Betsy said, a series of reports about diversion, and I've come to believe that diversion has been tragically underutilized in youth justice systems around our country and tragically undervalued, not just by system people, but by advocates as well. So why focus on diversion? Well, diversion works a lot better than juvenile court, much better. An avalanche of new research proves it. In 2020, the most comprehensive, carefully controlled study ever undertaken about diversion was done, and they compared kids who were diverted versus comparable kids who went to court on 19 outcomes, and the kids who went to court didn't do better on any of the 19, 0 for 19. And that study wasn't an outlier. Two meta-analyses, studies of all the available research, also found substantially lower recidivism, rearrest rates for kids who get diverted versus comparable youth who go through the court system. The other thing that we know is that diversion is badly underutilized, and it's not growing as a share every year for a generation, somewhere between around 45%, somewhere between 42 and 48% every single year since the 80s. Has said of cases that referred to juvenile court are informally processed, less than half, and it hasn't changed in a generation, even though we have all this information. And that's drastically different in other countries across the world. 75, 80, 83% of kids get diverted rather than processed in court when they're apprehended for a delinquent offense. And we're just not following, we're not keeping up. We're behind, we're underutilizing. And we're especially underutilizing diversion for Black youth, leading to deep and consequential disparities. In fact, disparities at diversion are one of the key drivers leading to the terrible imbalances we see in
What's up,
juvenile
baby? You need
nationwide. Hello? I'm checking. So we're going to talk today about restorative justice diversion, which is just one kind of diversion. And to me, it represents an especially promising approach. Like other approaches to diversion, it results in very low recidivism. In addition, restorative justice diversion has much higher satisfaction rates among victims and among youth and their families too. Restorative justice diversion addresses the public's strong sentiment to impose consequences on youth who commit delinquent acts. It's not just diversion away from the justice system, but diversion to something, into something meaningful that repairs harm and meets victims' needs. Plus, restorative justice diversion imposes meaningful accountability on young people. The young people must meet with and apologize to those they've harmed, and they must take action to repair those harms. Yet, despite all these advantages, we don't see a mass adoption or groundswell to replicate restorative justice diversion in the United States. I want to disagree politely with Betsy. This isn't a growing movement. It doesn't seem to be any more prevalent than it was years ago. There's not careful data about how widely it's used, but there's not really evidence that it's being used more and more. Rather, it's flatlined at best, I think. And why not? I think that there's a perception that diversion is a slap on the wrist, that it's not meaningful accountability, and there's another perception that restorative justice is a kumbaya approach that does much less than the courts to hold kids accountable. But these perceptions are just flat out wrong. The truth is that restorative justice diversion does a much better job than the court to assure meaningful accountability. Restorative justice also improves community safety by reducing reoffending rates, and it addresses victim needs better than the courts. For all these reasons, I strongly believe that restorative justice should be commonplace in youth justice systems nationwide, and it should serve a substantial share of all young people accused of delinquent conduct. So that's my thesis, and I want to convince you that all of this is true, and I want to encourage you to build or expand restorative justice programming in your jurisdictions. So that's my lead in, my opening. So let's get into it. here. So I'm going to focus on five themes in my talk today. What is restorative justice diversion? How effective is it? What are restorative justice diversion's advantages over the courts on accountability? What's the evidence that restorative justice diversion programs actually achieve better accountability? And what do victims really want, and why does restorative justice diversion deliver it better? So let's start by defining our terms. What is restorative justice? It's hard to define, but in essence, restorative justice is an approach that focuses on repairing the harm caused by criminal or wrongful behavior rather than determining guilt and punishing the offender. Instead of an adversarial battle between the state and the accused, the court's approach, restorative justice is an inclusive process that brings together victims, offenders, and sometimes community members to address the harm caused by an offense, find solutions, and work towards healing and reconciliation. So what is restorative justice diversion? Restorative justice can be used at any stage of the process before charges are brought, or as an alternative to adjudication for cases that are already filed in court, or during sentencing for offenders already convicted or adjudicated as guilty. Restorative justice diversion refers to cases where the restorative justice process is conducted before a court case begins, entirely replacing the formal justice system process. And who is it for? Which youth should be the targets of this? Restorative justice is appropriate for youth who've been accused of committing an offense that causes harm to another person or persons. That's why it's restorative. Restorative justice should only be used for youth who've committed a significant offense, not for a status offense or not for minor misbehaviors like shoplifting or schoolyard fighting or vandalism that are age typical for adolescents. Now, how widely is restorative justice employed in the United States? The short answer is that we don't really know. We don't have any reliable estimates on how many youth are referred to restorative justice diversion in lieu of formal involvement in the justice system. But there's no doubt that the number remains quite small as a share of all cases when youth are apprehended for delinquency. We have experiments with restorative justice and isolated programs that have been operating for decades here and there across the country, but restorative justice diversion remains an exception, not the rule. So what's the outcomes evidence supporting restorative justice diversion? There's not a ton of high quality research, but the evidence that we do have on restorative justice programs for youth and for restorative justice generally point to significant reductions in reoffending. Here are the results from three programs that had drastically lower reoffending. You can see that in all three, recidivism is much lower for restorative justice diversion. Now, what about victim satisfaction? I didn't make any tables or charts for it, but one of the most consistent findings of research is that victim satisfaction is far higher with restorative justice than with a standard court process. In the program in Los Angeles, in the Sentinella Youth Services, one of the leading diversion programs, a model, surveys find that more than 95% of participating victims say they're satisfied or very satisfied with the process. That figure is 90% or better for several other of the leading restorative justice diversion programs around the country that are taking victim surveys. By contrast, satisfaction among victims who go through the standard court process is typically low, much lower. Also, studies consistently find that youth who participate in restorative justice diversion contribute far more restitution than kids sent through the court process, and they complete more community service. In that Sentinella program, a study found that participants contributed an average of $80, this is an older study, $80 versus 50 cents for the kids who went to court, comparable kids. 57% of the Sentinella program youth completed their required community service versus just 77%, 57 to 7 of the kids who went to court. The pattern holds in many other studies too, perhaps because they've agreed to the restitution and community service themselves in a conference, perhaps because they've seen and spoken with and made promises to those they've harmed. Youth who participate in restorative justice diversion are far more likely to honor their restitution and community service program obligations. Now let's get into the question of accountability. And let's start by getting back to basics again. What does accountability actually mean? We hear this word all the time. All the time in discussions about crime and justice generally, and youth justice particularly. We hear it most often from those who oppose justice reforms and who are most skeptical of diversion and restorative justice. It's a fraught term that's often conflated with punishment. But properly understood, especially for youth, accountability is not about punishment. That's not just my opinion, it's the conclusion of the National Academies of Science in their most recent review of youth justice. Holding youth accountable, this is a quote, holding youth accountable does not necessarily entail the use of confinement or other explicitly punitive sanctions. Condemnation, control, and confinement are not necessary features of accountability for juveniles, do not deter or prevent reoffending, and should be avoided except in rare circumstances. That's the National Academies. So if it's not punishment, what is accountability? To me, as I think about it and as I've thought about it, accountability boils down to taking responsibility for behavior. It means apologizing. It means making things right and repairing the harm caused by an offense. And it means taking steps to avoid repeating behavior and victimizing others. Um, so there's an absence of accountability in the formal justice system. For victims, the process offers little satisfaction. Victims have little role in the court process. They receive no meaningful apologies. They have virtually no say in the outcome, and little action will be taken to repair the harms they've suffered. There is no healing in that process in the court. For youth who've committed the offense, they're often silent in court as their lawyers speak for them. The process is very slow and shrouded in legalese that they often don't understand. The consequences that get imposed on youth by courts, being placed on probation, having to show up for meetings, doing community service, often have little apparent relevance to their misbehavior. Um, sorry. So when you look at also, when you look at case outcomes in juvenile court, you find that many youth never face any consequences at all. Less than half of kids referred to juvenile court or formally processed in juvenile court actually get adjudicated as guilty. More than a quarter of the cases are dismissed entirely. And as we saw, youth who go through the court system contribute very little in restitution and community service. Restorative justice does a much better job of imposing what most people would think of as true accountability. There's prompt and relevant response where program staff are engaging and working with the young people almost immediately. The victim is deeply involved. Youth make apologies. Virtually all cases in restorative justice lead to result in agreements to repair harms and also to take actions to address needs and reduce the likelihood that the young people will reoffend. And again, they result in youth contributing far more restitution and community service. Now, not only do, sorry, did I go too far? No, I didn't. Victims express far greater satisfaction with restorative justice diversion than with the court process. We also have evidence that it improves their mental health. A recent study found that for victims participating in restorative justice processes, this is all of them, not just restorative justice diversion, for all restorative justice, the victims have reduced fear, reduced anger, guilt, anxiety, and distress. That study also found that restorative justice leads to reduced feelings of helplessness, increased security and self-esteem, and renewed feelings of control and empowerment. And yet, despite all this, it's often assumed in our culture that victims want punishment. They want formal prosecution and punishment. But it's not really true. In 2022, the Alliance for Safety and Justice conducted a national survey of crime victims. By a large majority, 72% to 22%, crime victims said that they prefer restorative justice and rehabilitative options over prison to hold offenders accountable. In Brooklyn, New York, a group called Common Justice operates a specialized restorative justice diversion program for youth and young adults accused of serious violent offenses. They find that 90% of victims choose to participate in the program, even though if they refused and the cases went to court, their attackers would likely go to prison. Now, experience shows that, and experts say that by and large, what victims want most isn't punishment. Rather, they have other priorities. They want to stay informed and have a voice in the process. They want to receive a sincere and meaningful apology. They want to have the harms they've suffered repaired, and they want to make sure the person who victimized them does not go on to harm others. That's their priorities. So at least to me, the evidence is overwhelming. Jurisdictions throughout the country should be investing in restorative justice diversion and making it the default option for many or most young people who commit offenses that harm victims. And yet it's not happening, at least not yet. So how can we build a movement to expand the use of restorative justice diversion for you in Illinois and throughout the country? I don't have all the answers. Obviously, if I did, then we'd might be seeing more of it. But here in the slide, you can see a few ideas that seem essential. There's overcoming negative perceptions about restorative justice and diversion. There's winning hearts and minds in the public, the press, and key decision makers like judges and prosecutors and legislators. There's creating dedicated funding streams that support restorative justice diversion, which are very scarce. And there's building capacity in program operators to provide quality restorative justice programs because it's a complicated undertaking to do it right. There's generating steady and substantial case referrals. And there's focusing restorative justice on the right youth, those with significant delinquency, not youth involved in petty misbehavior who should be deflected out of the justice system entirely. And it's also important to ensure, as in Illinois already has, that youth who participate receive protections to ensure that anything they admit to in a restorative justice process can never be used against them in court. Illinois has been a leader on that one. But I'm going to wrap it up here, and I'll be eager to hear your thoughts and your ideas in the discussion portion of the program later on, especially your ideas about what's going to really work to make this grow and happen, restorative justice diversion really expand for youth in Illinois. So thanks, and let me turn it back to Betsy now.
Thank you so much, Dick. We're going to hold off on questions if it's okay with you all and continue rolling ahead. We have Professor Michael Seng, who teaches restorative justice, constitutional law, and is a fair housing expert, talk about at the University of Illinois, Chicago Law School, talk about restorative justice in Chicago and in Illinois and the legislation that is currently pending to embed restorative justice in the Juvenile Court Act as an alternative to sentencing. So, and just, Dick, thank you for what you just did because it was terrific. Thank you for that. Okay, Professor Seng.
Thank you, Betsy. It's a pleasure to be with everybody today, and especially to be able to follow Dick because I think he's made some really important points that we need to keep in mind. And I think the legislation that has been proposed in Illinois really, in many ways, implements some of what Dick was talking about. As Betsy indicated, on April 16th, the Illinois House passed a bill sponsored by Representative Slaughter, and it's now in the Senate that would extend restorative justice in the juvenile court. The changes are actually quite modest, I think, but if properly implemented, can be very effective. The bill provides, first of all, that either the court or the state's attorney or both may establish a community mediation program. And that's really important. Right now, that power is given to the state's attorney. This would expand that power, so it's retained by the state's attorney, but also the court itself could institute a community mediation program, which would take place right at the beginning of the proceeding and last throughout the proceedings. The bill also would provide that prior to sentencing, the court could, in exact languages, may require, when the mediation programs are in effect, require the parties to at least consider participation in a restorative justice practice. And again, it states precisely that the purpose of this is to reduce trauma, to restore community ties, and to repair harm. So many of the purposes that Dick has outlined would be are taken care of in this bill. The process is, of course, voluntary, and restorative justice, in order to work, has to be voluntary. The legislation also provides that any resulting agreement would be reasonable and proportionate and then would be presented to the court as an alternative to sentencing. So the amendments are really in keeping, I think, with the original purpose going way back to 1899 of the Juvenile Court Act as envisioned by Jane Addams and people like her. It I think is consistent with modern brain science that shows that the human brain does not really fully develop until about the mid-20s. And until that time, children are particularly susceptible to peer pressure and don't really understand the consequences of their actions. As Betsy mentioned, the Juvenile Court Act in 1998 was amended to include the concept of restorative justice. But again, the implementation of that has been somewhat rocky, depending upon different areas of the state. So the law would also, I would say, furthers the legislative aims in the Restorative Justice Privilege Act that the legislature passed in 2021, where the General Assembly encouraged residents of the state to employ restorative justice practices not only in justiciable matters, but in all aspects of life and law. And again, amending the Juvenile Court Act and bringing restorative justice more fully into that process is fully in keeping with where we should be. As Dick mentioned, restorative justice requires offenders to accept responsibility for what they have done, something that the present system really is very dismal at. The adversarial process encourages people to deny responsibility. And even when they do plead guilty or accept responsibility, it's generally to avoid adjudication and does not really encourage any sense of remorse in a victim. Victims are really without a remedy in these areas, as similar to the community, which is normally ignored in the traditional process. So by emphasizing the repair of harm, we're not only looking at the offender, but we're looking at the person who's been victimized. We're looking at the entire community. I would also say that this amendment is very consistent with what is the practice in Northern Ireland, which Betsy has introduced to us in so many different ways, both in her taking legislators to Northern Ireland to see what is going on and bringing representatives from Northern Ireland to Chicago to talk about their program here. And as Dick has mentioned, it's very consistent with what is going on throughout the world. Just as an example, Chile in 2021 introduced community mediation into their juvenile court process. And all of this is consistent with the UN Convention on the Rights of the Child, which we know the United States is the only nation in the world that has not ratified that process. In Northern Ireland, they have a youth justice agency, and they refrain from using the word juvenile in Northern Ireland. Juvenile is frequently associated with juvenile delinquency. They use the softer word child and emphasizing the positive aspects that can be achieved through focusing on the child. Children are listened to. Children, and that's the real advantage of restorative justice. Children are really participate in the solution and participate in what the remedy is going to be. So the end result in Northern Ireland and hopefully here in the United States and in Illinois would be to build constructive relationships that are long lasting. Northern Ireland stresses early diversion, and I think the amendment to the Juvenile Court Act goes a ways in promoting that idea and promoting the idea of safety for all, not only punishing the child, but ensuring that the child is safe, that the concerns of those who have been victimized are respected, and that the entire community is safe. We've seen the results in Northern Ireland. You have the reduction in cases that are being adjudicated, and most importantly, as Dick mentioned, the satisfaction of those who have been victimized, and ultimately a greater public trust in the system. So I think the Illinois bill that has been being considered now by the Senate and hopefully will pass the General Assembly, I think it really advances many of the goals that Dick has pointed out. I also want to emphasize that I don't think any changes in legislation or anything is going to really result in real progress without further education. We've got to educate judges in Illinois about what restorative justice is and exactly what it does, especially prosecutors who are the key to much of this, but also defense counsel, whether it be public defenders or defense counsel, as to how they can use restorative justice and how restorative justice is important. Court personnel have to be emphasized. And I think everybody in the juvenile court process needs to read Dick's study because that is really, I think, key and very important here in advancing the goals of restorative justice and ultimately advancing the purpose of Jane Addams, who really saw children as distinct from adults, seeing that punishment really did not work. Employing penalties does not work, and that restorative justice is not some kumbaya thing that is fleeting, but is really a solution. We know that restorative justice has its roots in indigenous societies. It's used in Hawaii and other places for family reunification in juvenile court matters. So even beyond the delinquency area, restorative justice is an important tool that we need to educate all of ourselves on. And I think the Illinois legislation is important and should be supported. So I'll leave it there and open it up, let Betsy open it up for questions.
Thank you so much, Professor Seng. I'm going to turn off the recording right now. All right.